Welcome to the M&A Healthcare Insights podcast, focused on identifying transactional truths for those who care. This episode is part of a series to identify the key members of a transactional team as we start to put together a deal. Who do we want to bring in to get us to that successful outcome? We've recently elevated our M&A advisory to a standard of an investment bank, which we'll get into in this episode. But we felt that it was important to bring in other experts and have them share their insights and considerations as we go into an M&A process. Today, it's my privilege to introduce Jack Carver. He's a longtime friend of the firm and an exceptional attorney. He's got expertise both in transactional law and also in the healthcare transactions that we are involved in. Jack is a partner at Honigman in Detroit. And with no further ado, Jack, welcome.
Yeah, thank you so much for having me. And like Andre said, I've worked with M&A Healthcare Advisors in various capacities for several years, and it's been a great relationship, and I'm happy to be here today. As Andre also mentioned, I'm a partner in Honigman, which is attorney of about 300 attorneys based in Detroit with offices in Chicago, throughout Michigan, and then also in Washington, D.C. And we're a full-service law firm, but we spend most of our time, I think, on transactional matters. We're one of the most active M&A firms in the country, especially for our size. And one of the reasons why that is because we do a wide range of deals and kind of firms our size. So we do very large deals, and then we also do a lot of kind of smaller deals, particularly for our private equity clients in terms of add-ons and a lot of activity there in the healthcare space. And I think in my own practice, I do a lot of sell-side work with clients in the healthcare space. And as we can get into further, that my representation is kind of informed by our experience on the buy side and our healthcare specific law team, which we can talk about further. But very happy to be here and look forward to the conversation.
Yeah, thanks, Jack. We've been involved on a number of transactions together, and they've always gone well to the extent that I think we served our clients at the highest level. And one of the things I've always respected about your approach has been that it's very solutions oriented and really focused on the practical. I mean, as you know, we represent the lower middle market, which is that small to medium sized business. And that client has a tremendous amount of expertise and sophistication in their business, but they don't necessarily know how this M&A process works. And you could very quickly inundate them with risk factors and the legal components of these transactions. But you have a good way of presenting it where it's like, these are the things we really can worry about, and these are the things we don't have to worry about so much. And I don't want to do it in a way that isn't in your style, but I think it's very comforting to our clients when you come in and you walk them through these documents, and from the LOI all the way to the definitive agreements.
Yeah, and I think like you said, I am very cognizant of that. I do this all the time, but that most people don't, and that it's a very stressful process. It's a very confusing process oftentimes. So I try to go into each representation with a good deal of empathy about what a client is embarking on. And these are usually, like you said, very smart and sophisticated people, but they're just in a domain that's a bit foreign to them. And so to try to walk them through the process and to keep my own ego out of it as much as possible, and really just try to be there as somebody that answers any questions that they might have, and not have them feel like they're working with some big scary attorney that they're not comfortable asking questions about or to. So I take that compliment very, very sincerely, and it's something I focus on.
Yeah, no, and I think from our perspective, we like to get you in early too in the process. And sometimes the client will have an attorney that they know that is working with them, in a family office capacity, or maybe working with them, that's worked with them in some other legal, maybe tax, maybe litigation, something. But you have a unique you have a unique sort of set of experience and skills as it relates to the M&A process. When do you like to come in, and how do you come in and not displace other representation, but come in and complement it?
Yeah, I think the existing counsel is always extremely important for from a kind of knowledge perspective and knowing the business perspective. What we can bring to the table is we see dozens, if not hundreds, of LOIs each year and have a very strong name in the marketplace. And I think that does two things. One, we know what terms you can negotiate in an LOI, and we try to push for that early on to get as much clarity between the parties. Because you think about the transaction process, I mean, the LOI is really functions to kind of take the business off the market for some period, and it's a period when the seller has a good deal of leverage. So you exert that leverage and trying to get the best commercial points, which obviously your team does so well. But then it's also an opportunity to kind of get some of those liability and risk factors to a place that's favorable to the seller, and get them to commit to those in the LOI, which, although it's a non-binding document, usually proves pretty difficult for the parties to walk away from. I know you and I often hear from both sides, the LOI said this, the LOI said that, and if it did clearly say something, it's pretty bad form to go in a different direction unless you learn something truly new.
What do you look at mostly when you get into that LOI? From our perspective, like you said, there's a commercial focus, right? We want to make sure that the pricing and those terms around the deal structure, certain aspects like the type of deal that it's going to be, asset versus a stock purchase, those things are important to us. But there is some overlap in those commercial provisions, and then there's also a focus on the other legal provisions, indemnifications, representations, and warranties, those types of things. Where do you like to separate the tasks when it comes to working with a team like us?
Yeah, I think when you talk about the purchase price, that's usually more in your court. I think where it can get bleed into a conversation is when a seller wants to do a stock versus an asset deal, or a stock deal that's treated like an asset deal for tax purposes, and making sure that we think through the tax consequences of that change, and seek a gross up in the LOI if the approach that the buyer is proposing is less favorable than another kind of legal structure for tax reasons. And then, on the pure legal side of it, I mean, I think largely what our goal in the LOI process is to try to get a commitment from the buyer that they're going to treat this like a market deal in terms of allocation of risk, and then push for the seller favorable side of market. So, we're not going to go in there and try to put all these crazy terms in there just because, we can, but we know, what's a seller favorable survival period for reps, and what's the seller favorable cap on indemnification within market standards. But if we can get that commitment at that point, it saves a lot of heartache down the line, and just lets the negotiation focus more on the business discussions where they really should be.
Yeah. So then to clarify, you really like to come in right around. I mean, you preference to be there, from the absolute beginning, but you like to come in no later than when that LOI is being negotiated, or we have multiple LOIs and we're reviewing them, trying to make a decision on, who the counterparty will be going into an exclusivity period.
Yeah, that's right. That's totally right. Because I think being able to present the total package to the buyer, because we talk about the purchase price and we talk about the legal, and to some extent, like we said, they are distinct, but in another, they really are kind of one proposal. And I think, like any negotiator, you're in the strongest position possible when you know all the chips and you have all the chips ready to negotiate at one time, rather than, making concessions at one point and then having to negotiate something in a new negotiation context outside of the concessions that you already made. To be able to put forth your kind of total offer, total presentation at one time, I think puts you in the strongest position to get the best deal.
Yeah, I can't tell you how many times, we're sitting there with clients and they're, saying, why do we need to have, so much around this non-binding, right? Why do we have these conversations need to be so extensive around these non-binding documents? Our response to that is that, well, we really want a mini version of the larger document down the road. And like you said, sort of identifying where the issues are, but how along the way, and then sort of getting them done with on the front end. But how do you address that for a client who is trying to, let's say, uh, cut on costs a little bit, not trying to incur too many costs on before they're in exclusivity on an LOI, or a client who's just thinking like, look, I just want to get an offer and I want to sell my business for that. Where how do you usually respond to them in that regard?
Yeah, I think two things. One, the LOI negotiation process, my involvement in that is not usually terribly extensive. I mean, it's not like a big piece of work by any means. But I think what it can do is just make the legal negotiation once you're under LOI go a lot smoother. And a good deal, taking these points kind of off the table early on can make the legal part of the negotiation very easy, because the situation you don't want to be in is you don't really know buyer's attorney, and you agreed to this exclusivity, and then they come in with kind of off market terms, or and then you're kind of starting from square zero, just trying to get them to agree, bring things back to a middle ground. Whereas if you start the conversation early, you can get a commitment that this is kind of where we're starting from, and then let the process just kind of play out in a natural way in the purchase agreement stage. So I think the short answer would be it ends up saving you a lot of money.
Yeah, I agree with you. We've found in so many cases too that when we work with you, uh, that as we, hopefully, right, we get through the due diligence phase and then we're negotiating now the definitive agreements. We're also, those definitive agreements, they come back very quickly. We can use the LOI as our sort of playbook, right, for this is what needs to be in this definitive agreement. And then at that point, it really becomes, maybe some fine strokes, but it's more about making sure that the definitive agreement addresses the ancillary components of the deal, like employment contracts, and which you also are involved in, subscription agreements, right? If there's some form of rollover equity of some kind, operating agreements, if there's contemplating of some kind of partnership going forward. So I think in that regard, it's a lot more comforting to know that the main body of the document is going to come back and it's going to be in line with what we had already discussed and formalized in the LOI, which is funny because it's a non-binding agreement, but in many ways, it's just it is basically the mini version of what we want to see when we get through the diligence phase.
Yeah, that's totally
Yeah.
right.
When you think about the aspects of an LOI, and I think LOI is so important because we so much of how we represent the buyer, the counterparty to the client is in the LOI. We can see a lot about who the buyer is, and how they're contemplating, and the structure of a deal. Can give us a sense of the likelihood of it actually happening. But when you think about an LOI, what do you think about in terms of sort of the absolute need to have components of it, and in order for you to even consider it an LOI?
I mean, I think at the most fundamental level, it's kind of a price commitment and an exclusivity provision. And I mean, I think it's not a deal breaker if that's all that it is, but I think it just opens up a lot more complication later on. So I think if you're talking about like a minimum, you know, legal terms that I like to see, to kind of see it as a fully fleshed LOI that's going to save everyone heartache and has been kind of the negotiations have been properly conducted at this stage. I think it's some statement about the representations and warranties, the caps on liability, and then just kind of the survival, how long you're going to have to be thinking about this stuff. And then, of course, if there's expectations about post-closing employment, it's good to kind of flush that out now, because some sellers want to stay involved. Some sellers absolutely do not want to be involved, and kind of resent the fact that they're asked to later on. So, understanding the buyer's post-closing operation of the business, expectations for the seller as far as future employment or transition services, try to flesh that out as much as possible. Um, but I think the most important thing is that it's non-binding.
Yeah, I like that. I like that concept, because sometimes we will actually see, an LOI that won't have a transactional value attached to it, or it'll be some larger range, and we don't even know. Like, the range is there on the multiple, but then there's also, we don't even understand necessarily the variable of EBITDA or whatever other pricing metric they're using. And then it just becomes difficult to say, okay, well, we're going to give you all this exclusivity and all this time away from other opportunities, without you giving us at least some, sense of where the price is.
Yeah, yeah, and they'll always say that it's kind of subject to due diligence, but it kind of puts the onus on them to have really found something significant to justify a change in price. Otherwise, it just becomes a kind of a retrade situation, and that usually leaves a bad taste in everybody's mouth. And those deals are often the ones that don't complete.
That's right. That's right. Well, let me shift gears here a little bit. So, as we've transitioned towards becoming, would be considered an M&A advisor, over to a more traditional investment bank, with all of the sort of ability now to do what we can, as a registered, agent of a broker dealer. And so, from a financial perspective, that gives us some flexibility now, that we didn't have before. Like, we can do minority interest transactions, we can do capital raises, we can, look for recapitalization opportunities with our clients, partnership sort of negotiations, anything around securities related transactions. We don't have anything that keeps us, from a compliance standpoint, from doing that. So that's a benefit. But I want to talk to you more about sort of the fact that now we're also in a legal compliant mode, where as this is a highly regulated market, and now it looks like the SEC and FINRA are overseeing these transactions, on a much smaller level than they have before, right? And I would just like to get your opinion, from a legal perspective, where the advantages of our compliance, as a financial firm are.
Yeah, I mean, I think you mentioned the scope of services is huge. You never know what direction a transaction process is going to take until you take it to market. And having a firm like yours that is now kind of widely licensed just makes a seller able to think through a lot more possible outcomes. So I think that's great, more from the commercial side. And then I think, on the legal side, you're already there's going to be some survival of liability with respect to the sale of your business. You're going to have made representations and warranties about the business that are going to last for some period. So there's going to be a little bit of things that are still on your plate after you sell the business. But one thing that you don't want on your plate is, who you worked with to sell the business. And knowing that you guys are overseen by a third party now, I think can give sellers a lot more comfort, and just put one less thing maybe out of their head as far as a risk, because you don't want to be roped into some type of regulatory issue in terms of the fee you paid your broker.
Yeah, it kind of feels like it's been pretty loose, in the M&A world, right? I mean, there's so many different categories of representation out there, from the business broker to the finder to the M&A advisor, and it's tough to really substantiate the differences between those, right? Some might say it's a transactional threshold in terms of size. Some might say, it's the definitely the quality of the representation. I think from the standpoint of making this move into this category, it's really been about affirming that what we do is a representation from beginning to end and beyond, right? I mean, we might have a conversation with somebody who's not ready to sell their business for a couple of years, but we're having that conversation and we can actually walk through them, sort of the operational aspects that they could be doing, consult with folks like you on the legal, consult with clinical and other financial firms on what they can be doing, in terms of their accounting practice and all that. But we get in very early. We like to get in early, and we might stay around in perpetuity, right? And we have clients that we've been working with many years after the transaction because they might be looking for other opportunities and all that. We feel like this makes a clear statement to our clients, to potential referral sources like yourself or those who we work with on a deal team, that we're serious, that we care about the client, we care about the quality of work we do. And I'd just be interested to get your opinion on, I know that you know that already from us, but I'd be interested to get your opinion if you didn't know us, if you would feel like, look, I mean, this is a boutique firm, but it's an investment bank, and that means that they're beholden to you at a much higher level than these other types of firms.
Yeah, I mean, there's a lot of business brokers out there, and you don't really know what you're getting in with a lot of them. And I think when you see someone take the time and effort, because it is significant to go through the process of becoming compliant, I mean, I think it just evidences a seriousness and signals to the marketplace that you guys care about doing this the right way. And I think when you're trying to sell your business, it is going to be a reflection on you, who you're working with to sell the business. And when a buyer, an institutional buyer can look you guys up and see, you're licensed, I think it makes a difference.
Yeah. Okay. Well, thanks for that, Jack. And I know it doesn't necessarily make a difference between, us and how we've conducted ourselves and how we will continue to conduct ourselves. But we just think that it's such an important message to deliver. And the funny thing about a lot of the clients that we represent is sometimes they don't know the difference between what good service is and what bad service is, because maybe this is the first time and the last time they'll ever go through an M&A process. But I think you and I know the difference, right? And also, and this is a good transition into the deeper markets. But I think also we know that with quality representation and with the right members on a deal team, you increase your probability of a successful outcome. And like you said earlier too, the idea of the costs associated with that are much like you want to take those on the front end, and you can mitigate those costs through the entire deal process with the right type of preparation and bringing in folks who understand the market and understand how to run an appropriate process for the deal type or for the business that they're representing. So yeah, no, I appreciate that. Let me ask you a little bit about the market and in general what you're seeing. I think that for us it's really been a roller coaster, right? I mean, we had this, there was some pre-COVID. I mean, there was always activity, but then there was COVID, and there was obviously a big decline. But then there was this huge increase, 21, 22, record multiples and activity, and then we've seen this sort of decline. Just love to get your opinion on sort of is that been your experience, and sort of obviously you're always working, right? There's always something, whether it's up or down. But how do you see it in the M&A context, and and maybe some thinking around where it is now and where it might be going, in the next couple of years.
Yeah, I think everybody, during the 21-22 period that you were talking about, you always get the impression that this is kind of the new normal, and things are always going to continue this way, and that proved not to be the case for reasons that are probably obvious now that when we look back on it in terms of the PPP money and just the general kind of state of the market during that period. And so now I think everybody's trying to figure out, is this the new normal, or is this, right now, is this kind of just, are we back to kind of the normal state of things, or are we still in kind of a little bit of a decline? And we're seeing, more and more activity. It's not like it was in 21 and 22 in terms of the positioning of the sellers and the leverage of the sellers, where they could just pretty much ask for the moon and the stars and get it. We're seeing a lot more kind of seller notes and more flexible terms of financing to deal with higher interest rates, which a lot of financial buyers feel the burden of very significantly right now. So I think we're seeing more and more activity, but I think if 21 and 22 are always going to be your standard, you might be disappointed for a while.
That's that's true, right? Like lower the bar a little bit,
Hmm.
relative to those years. How do you, we talked a lot about the sell side, but how do you represent, when you're representing buyers, on that side of the table, how do you look at these transactions in terms of, I mean, there is definitely, I would say, some volatility that's occurred of late where deals are falling out, whether more frequently than they have traditionally, in a due diligence phase, and in some cases getting far along into a definitive agreement phase of a deal, and it falling through, right? How do you work with buyers in that regard, and why are those decisions being made to break up a deal?
Yeah, I mean, it is something that happens, and I think again, probably 21 and 22 people were willing to take on risks that they may have called off a deal for previously, and now there might be kind of a more typical, risk assessment going on from the buyer with respect to things they find in due diligence, and I think that also comes from the financial perspective. I mean, sometimes something can change from a financial perspective over the course of the deal, which just makes this the buy side process not as attractive as it was when it's starting out, because you have to remember it's not binding on the buyer to finish the deal either. And they can walk away for any reason that they want. They usually don't, because they invest a ton of money in doing diligence and hiring lawyers, and deals acquire a certain velocity once they, or momentum once they get going. But I do think that in a more typical market like we think we're in now, there are things that can stop that momentum, whether it's things that happen on the deal side as far as diligence, or things that happens in the buyer's own business.
Do you think that the market, when you say more typical, I think really what you're saying is that you can't use 21, 22 as outlier. When they're outliers in our analysis, right? The bell curve is sort of where, if you plat this out, right? It's like where we are, sort of kind of right now. But I do feel like we're, maybe a deviation away from where the hump of the bell curve is, in terms of just the way deals are coming through. And I do feel like buyers are getting into transactions and getting out of them, more than I've ever experienced in some ways. And look, it could very well be that, again, you had all this artificial influence from, whether it was PPP or other stimulus programs, and buyers got information based on those numbers, and as that starts to burn off, from these businesses, and you start to see the true business, maybe buyers are responding to getting information that wasn't completely accurate on the front end. I mean, I think we do a good job of making sure that we present the business, as is. We adjust for, EBITDA and sellers' discretionary earnings and for items such as that. But I don't think we've never tried to inflate a business how it looks. But I just wonder if buyers have expectations on businesses that sort of, drag from where we were in those outlier highs a couple of years ago.
Yeah, I mean, I think a lot of buyers borrow money to buy companies, and when you're borrowing money at 7 or 8%, it's a lot different than 2 or 3%. And sellers sometimes their expectations haven't come around to that, and I think that's kind of been the message in the marketplace for the last couple of years. And I think we're starting to see more of a alignment of expectations, but as like you said, I think there's still some work to do, and that can lead to buyers stretching themselves, and then maybe they have the expectation that interest rates are going to fall, and then they don't, and then they're reevaluating the acquisition again. So there's just a lot of kind of extraneous factors right now.
It's amazing how much these debt markets move what happens. And you see the equities markets. I mean, as we're talking too, they're hitting new records and everything's going on. But that's such a like an emotional piece, of what's happening in the economy, and such a small slither of what matters really to us, right? Like that sort of large cap equity stuff that's going on. There's some information there we can gather, but really it's all about the debt markets. And so as you know, when the Fed meets, the FOMC meets, when they start talking about where interest rates are going, it's interesting how that's really what moves, definitely the financial buyers, right? Which is where we've seen the biggest drop off in the last 18 months, right? They're so moved by what's happening in those debt markets. And so as we talk about types of buyers, right? We have seen, and I don't know if necessarily it's a huge uptick, but I think definitely strategic buyers see opportunities now, and as multiples soften a bit, or as sellers come into the market that may not have the expectations they had a couple of years ago, I think those strategic buyers are really well aligned to come in and make these deals work. Do you see, like, where do you see the distinctions between strategic buyers and and the financial buyers that you represent?
Um, I think strategic buyers usually have a much a larger view of where the acquisition fits in their kind of organization and their growth plan, and financial buyers might just be a bit more opportunistic and just say that this is a good business, it's a good price, and I want to buy it. And I think you know that can lead to strategics paying more than financial buyers when it kind of makes sense for them. For there's externalities that might not be present with other buyers because strategic has a place for this company and its vision. I think during the 2021 22, private equity was very active because they financed their deals and they could get cheap money and they could usually outbid people, and a lot of times use rep and warranty insurance and offer sellers the prospect of just kind of walking away and not thinking about the deal ever again, which some strategics that come around to, but it's still less common than it is with financial buyers.
Do you find that you're working with more strategics these days on the buy side, or as counterparties on the sell side?
Yeah, I think it's become more evenly balanced than it was in 21 and 22 when you really saw a heavy influence of private equity in the lower middle market and in the middle market. Obviously they're still very active there, but before I think we'd see LOIs and the top 7 or 8 suitors seem to be financial buyers. Now that isn't always the case.
All right. Well, let me ask you too. So I've been thinking about when you set up the information gathering for these transactions, and the more I see it, it's like there's 3 folders that are created in the data room, at least when you're getting started, right? There's a financial folder, there's an operational folder, and there's a legal folder. When you think about what a seller can do, in terms of populating that legal folder, like what do you think they can do uh, prior to going into a transaction from a legal standpoint to make the company more attractive and to also give them a higher likelihood of a successful outcome?
Yeah, I mean, I think transactions professionals know what a buyer is going to ask for, and being prepared to respond to those requests can make a huge difference, because once you get under exclusivity, the period is going to go very fast. There's going to be a ton going on, and if you're trying to find that the countersigned version of that contract that you signed 4 years ago, that's not going to be what you're wanting to do at that point. You're trying to run a business while you're also trying to sell it. It's very stressful. So I mean, there's basic things like they're going to want to the buyer's going to want to know about all your contracts. They're going to want to know about your regulatory posture. They're going to want to know about your employees, and they're going to want to know about your real estate and your other assets, and having that stuff organized and prepared in a data room. And when when a buyer gets under exclusivity, you send them an invite link, and 85% of their questions are already answered. That makes a huge difference.
Yeah, yeah. I think that we have definitely experienced uh, deal killers in the past, and things that come up, and usually it comes up as a something that the client just didn't bring to our attention, or something that was not populated in the data room. Maybe it was prompted or unprompted. But do you have sort of kind of a word of advice for sellers when it comes to populating data rooms, when it comes to providing information, especially from a legal standpoint? I mean, what's sort of your position on that with them?
Yeah, I mean, I think being transparent and disclosing as much as is appropriate, and talking with your advisors about, if you have a question about something, don't just put it in the back of your head. Talk to your attorneys, talk to your advisor about it. I think dribbling things out as the process goes on, especially if they're disadvantageous to you as a seller, can just leave a bad taste in a buyer's mouth. And most of the time, even if you got some bad facts, every deal has some hair, and usually buyers find a way to work around it and deal with it. But when it comes at later stages of the process, there's more emotion involved, and there's more of kind of maybe a breach of trust feeling involved. So to get as much on the table early is in everybody's benefit.
Yeah, I mean, trust such an essential component of it. We can do all the throw around all the paperwork and show all this evidence, but at the core of it, if there's still doubt, particularly in the attorney's mind, right? Because in many ways, you're sort of certifying that that you've diligenced this in many ways, and you've gone through it. And so I think it's such an important thing to continue to mention that, look, every business has issues, right? And in many respects, you and I have seen it all. You want to make sure that the buyer's familiar with those issues early, because that way we can truly start talking about how to either resolve those issues, or how to work around them in a way that we can get the deal done. So
Mhm.
yeah, it's just
Yeah,
those
there's
things.
lots of solutions. Yeah, there's
Yeah,
lots of
yeah.
ways to figure things out.
That's what I always refer to you, Jag. Is I go, he's a troubleshooter, not a troublemaker, and and that's kind of my two attorney categories. But you really do genuinely come in, and for me, are able to really help problem solve around what I'm getting, information I'm getting, and working through it. And I feel like when we work together, when we get in early, it's been much more efficient and of much greater value for the client in the long run. So no, it's great. Well, look, I think we covered quite a bit. Was there anything specifically that you'd like to talk about? I mean, I think you've really grown in the firm, and in your career, deservedly so. Sounds like with Honigman, there's continued growth there too. I know that I've worked with you with transactions across the nation, even in these challenging states like California or New York, and that you've got a great healthcare team, you've got a great tax matters team. Is there anything about Honigman or about the representation or about the process that I missed today in highlighting?
No, I mean, I think we covered it, and that we're a full service law firm that does, that I would say we do a lot of lower middle market work, but we do it at a very high level, and we do deals very efficiently, and we're built to do deals. We have the staffing to do deals. We have the technology to do deals, and that's what you want in this already very stressful process, is to work with somebody that's been there before, and that's the same, a core part of the value that you guys bring to the table too. And I look forward to working with you guys as you embark on this next chapter in your firm's history. And I think it's all a very exciting time for both of us.
All right. Well, thank you, Jack. Great seeing you as always, and I'm sure we'll be seeing each other soon enough.
Thank you.